Hi, everyone. Thank you so much for joining and for your patience while we're getting things sorted here on our end as the event coordinators. I'm really happy to have you all with us here this evening or afternoon, wherever you're located. Um, my name is Maggie Ellinger Locke. My pronouns are she, her, hers. I'm the co-chair of the Washington, D.C. chapter of the National Lawyers Guild. And I'm going to get us started here in just a moment. We are still hoping that we have a couple more folks joining us who will be speaking this evening. We're just waiting on. But I'm going to go ahead and kind of like set this up and intro where we're at. So this is, I also want to open by acknowledging that the Washington, D.C. chapter, reform where it live in those of us who are part of the DMV, we're part of the colony of the so-called United States of America, founded on the unceded lands of the Anacostan and Piscataway peoples. And I am extremely honored to welcome you here for what I expect will be a fascinating event. Hearing from incarcerated abolitionist journalist Lyle May, who will discuss with us his new book, Witness, an Insider's Narrative to the Carceral State. But before we get to that, I want to thank our co-sponsors of the event, Jailhouse Lawyers Speak, Muslim Counterpublics Lab, the National Lawyers Guild, and the National Lawyers Guild Mass Incarceration Committee. Thank you all. And a special thank you to NLG's Director of Communications, Marco Luna, for making the flyer for this event. So it's just some quick housekeeping. I want to name that this is a Zoom event is being recorded, so please be aware of that. And it's also set up as a meeting and not as a webinar, so please remain muted unless invited to speak. We also just suggest that you set your Zoom settings to spotlight the speaker, so you can see them visibly as they talk, and please make robust use of the chat function. You can leave any questions for the speakers there. And before we get to Lyle, we have a couple of speakers we're going to hear from who will help us ground this event and provide context for the issues discussed in the book Witness. And then we'll hear an introduction of Lyle, followed by remarks from Lyle himself, and then conclude with a Q&A. And that's when you all as the audience are welcome to ask any questions. Please, and I urge you to make use of the chat function throughout the event. So that's the sort of order of operations. And so before I pass the mic, I'm going to provide intros for our guest speakers. Not quite sure all we're going to have here for sure. We're going to kick things off with Jennifer Jones, who is a civil movement and human rights attorney and managing attorney at For the People LLC, who works on prisoner rights. Jennifer litigates complex civil litigation cases involving the rights of political prisoners, employment discrimination, and police misconduct. This work has led to binding federal law concerning prisoner constitutional rights. Jennifer is a carceral law scholar, law school instructor, serves as editor-in-chief of the National Lawyers Guild Law Review, also chair of the National Lawyers Guild Mass Defense Committee, and co-chair of the Mass Incarceration Committee. She serves on the board of directors of NCBL, the National Conference of Black Lawyers, serves on the board of directors of the Faculty of Federal Advocates, and is recognized as one of Denver's 40 under 40 young professionals. She represents and works with several political prisoners, including Leonard Peltier, Eric King, and Sundiata Jawasa. To intro Lyle, we are also going to hear from Dr. Maha Hilal, who will introduce tonight's featured speaker. Dr. Hilal is a Muslim, Arab American, and an expert on institutionalized Islamophobia, the war on terror, and counter-narrative work. She's the author of the book Innocent Until Proven Muslim, Islamophobia, the War on Terror, and the Muslim Experience Since 9/11. And her writings have appeared in Vox, Al Jazeera, Middle East Eye, Newsweek, Business Insider, The Daily Beast, and Truth Out, among others. Dr. Hilal is the founding executive director of Muslim Counterpublics Lab, an organization that works to disrupt and subvert dehumanizing narratives that are designed and deployed to justify state violence against Muslims. Dr. Halal is also a member of DCNLG and a former DCNLG executive board member. All credit for tonight's event should be awarded to Dr. Halal, and we are grateful to her for making this panel possible. So thank you again, everyone, for joining. We are really grateful for your time on this important topic, and I'm going to go ahead and pass the mic to Jennifer.
Well, thank you, Maggie, and good evening, everyone. And foremost, thank you to the Washington, D.C. chapter of the National Lawyers Guild, especially Maggie and Maha for convening this important program and for inviting myself and colleagues. The title of Mr. May's book, Witness, is so appropriate not only for him, but for all of us. We all must bear witness and face the corrosiveness of the carceral state to see it for what it is in order to transform it. You know, prisons are often out of sight of most of the public, highly restrictive, often located in very rural areas, and bound in the proverbial red tape of policies and procedures that deliberately seek to divorce and mute the voices of prisoners to the outside world. So Mr. May's account leads us through the coarse and problematic landscape of the sprawling carceral system, from the nuances of capital punishment to life without parole and death by incarceration, to systemic biases, to retaliation against prison writers, including jailhouse lawyers, to the surveillance, which now reaches beyond prison walls, a form of repression in and outside of prisons. All of these issues call for a grounded and really serious discussion and action towards abolition, in my view. And it will take more than eradication of qualified immunity or the Prison Litigation Reform Act. As May points out, it is to tinker around the edges of mass incarceration to do those things, to be reformist. The issues related to the carceral state, prisons, and prisoners must be brought to the forefront of the American consciousness. And, you know, in fact, it has. You know, in this time of deep repression, we are under no illusion that the most repressive practices we are seeing in the streets and campuses of institutions of higher learning and workplaces, both public and private, find their origin in part on the battlefield and in prisons. What occurs in prisons threaten everyone, both incarcerated and not incarcerated. Mass incarceration has always been about the repression of the effectiveness of movements and marginalized communities, and candidly maintaining enslavement and apartheid in a thinly, neutrally veiled manner. For instance, federal old law prisoners, many of whom are political prisoners, are essentially stuck in prison, aging, medically neglected, with prolonged sentences way past their time due to legal defects, such as not being eligible for the First Step Act. But a closer look into this phenomenon reveals that it is by design. It is not an oversight. It is a politically motivated, deliberate tactic intended to ensure that the prisoner never makes it out of prison in any condition to advocate for themselves, their community, and most importantly, against the state. So too it is with the repression we are seeing today, from Cop City to Palestine solidarity. And so we must bear witness to the machinations of the colonial state to disarm it. So I'm grateful to be here with you today. I'm grateful for Mr. May and his work, and we'll pass it on along to the next speaker if they are present.
So I think that next speaker is going to be Maha to intro Lyle.
Give me like 2 minutes. Lyle's just calling back, but in the meantime, can you make me the host so I can share?
Absolutely.
And just
practice that earlier. Where?
For this call. This call is from Lyle May, an inmate at Central Prison. This call will be monitored and recorded for customer assistance, collection, or thank you for using Global Tel Lane. Hello.
Hey, Lyle, I'm just about to introduce you, okay?
Okay.
1 second, I'm gonna.
You should be
Sure.
host.
Okay, cool. Can you see Lyle's picture? Yeah?
Yes. Yes, we see it. I do. That is-
Okay, awesome. So I'm gonna intro Lyle. But before I read his biography, I just wanted to say a little bit about how Lyle and I met. So we were part of an abolitionist journalist program last summer through Interrupting Criminalization. And the folks on the outside were paired with folks on the inside. And so that's how Lyle and I got to know each other. You know, we instantly connected and share a lot of things in common, including the love of writing and our work and fight for social justice. And just having gotten to know Lyle, you know, over the last, let's say about 9 months, has just been such a great experience. You know, he's one of the most determined and dedicated people I've ever met, and very thoughtful, brilliant, and kind. And so it's really exciting to be able to have Lyle here to share more about his book, which I am working through currently. But also encourage you all to ask a lot of questions. Lyle does a lot of public speaking and really wants to, you know, get the word out about, you know, the carceral system. And it's rare, of course, to get this kind of perspective from someone who is incarcerated and has been on death row for so long. So in terms of Lyle's formal bio, he's an award-winning incarcerated journalist, public speaker, author of Witness, and Insider's Narrative of the Carceral State, an Ohio University alum and member of the Alpha Sigma Lambda Honor Society. To find out more about his work or how to contact him
This
directly,
call is from a North Carolina correctional facility.
you can contact him at lylecmay@gmail.com, which I will stick in the chat, or lyleclintonmay@gmail.com. I've also stuck the link tree for Lyle in the chat, and I'll put it in again so you can figure out and buy his book, review it on Amazon, Goodreads, read some of his op-eds, and just show as much support as you can, because we know how much the state tries to suppress incarcerated voices. So with that, I will hand it over to you, Lyle.
Thank you. And thank you to the National Lawyers Guild DC chapter for hosting this event. I'll just go right into it since I think this is a wonderful introduction. Witness began as a number of published and unpublished essays and articles, as well as prepared lectures given at a number of different universities around the country. The idea that there needed to be more thoughtful narratives from the inside, in particular, one that doesn't add to the sensationalization of prison life that is sometimes on TV. My thought in creating Witness was to explore what impacts everyone in confinement, the politics and policies driving America's extreme sentences. This meant examining mass incarceration through the prism of death penalty and life imprisonment, when too often the focus is on nonviolent crimes and pretrial detainment. As such, Witness argues against the need for capital punishment, perpetual confinement, by illustrating the human, fiscal, and moral costs of such sentences, but also their ineffectiveness as a deterrent. What those of us on the inside understand better than any policymaker ever will is that death and life without parole sentences are torture. Witness illustrates some of the physical and psychological torment we experience and why it's increasingly ignored by the courts. As an incarcerated journalist, I often rely on my experiences and those of my peers to decode topics in criminology, especially classical criminological theories that contribute to draconian crime policies and brutal dehumanizing prison conditions. Witness counters these tough on crime narratives with lived experience and exposes the myths and misconceptions propagated both online by political pundits and public officials seeking re-election. In that sense, Witness engages in the task before the state, acting as a check against elected officials who profit from and maintain the carceral state. It's independent reporting that calls out media outlets that parrot state's narrative on, that parrots the state's talking points without fact checking or corroborating with incarcerated people. Witness combats the intellectualist agendas that prey upon a naive public with fear mongering, ignorance of the law, stereotypes, prejudice, xenophobia, and empty rhetoric that proliferates the country with violent human warehouses. High rates of recidivism and more crime because prison is in fact criminogenic. On the front line of that fight to end mass incarceration and return the pendulum of punishment to the center of accountability, Witness is an act of resistance, shout from the dark, and charge that the failure of prisons and continued ineffectiveness of ultra-punitive laws without mercy are a public responsibility that can't be denied. Now that you have a general idea of the themes and motivations behind my book, let me give you kind of a brief breakdown of its composition. So Witness is broken. It has 31 chapters divided into 5 sections. The first section, State of Violence, covers capital punishment, death row executions. Part 2 is Carceral State, which deals with life imprisonment, parole, and the dismissal or elimination of parole. Part 3 is Culture of Control, deep dive into prison journalism, challenging the tough on crime narrative. And Part 4, Witness, self-titled, advocates for abolition and reformation. And Part 5 is Fury Resistance, discusses various types of activism in and around prisons, providing both examples and a blueprint for anyone seeking to shrink or eliminate the carceral footprint in their community. And at the end of each section, Witness is a snapshot of activism, brief interviews with professionals on the front lines who strive to rehumanize people who've been thrown away by society as activists pursue demonstrative change in the way the criminal legal system blindly punishes with prison as a first resort. These interviews lend greater credence to the chapters in Witness, kind of living resources, striking a balance in perspective and showing that building up the world we want to exist is a collective effort. I'm going to read to you a chapter from Witness, both as a sample, but also as a lead into the second part of my discussion, where I'll delve into the need for greater vigilance in the face of judicial animus toward due process, which is chapter 14, Mob Mentality in Politics, the viral states where bad laws are made. I watched for my cell the January 6th Capitol insurrection unfolded on TV. Later, labeled like domestic terrorism and anti-government extremist protocols, used by various journalists and lawmakers calling for justice. Incoming U.S. Attorney General Merrick Garland promised to prosecute perpetrators.
This call is from a North Carolina correctional facility.
And anyone responsible for undermining democracy. Although a law and order rhetoric is intended to rally and reassure, it's reminiscent of an era in the 1990s that brought the Violent Crime Control Law Enforcement Act, the Anti-Terrorism and Effective Death Penalty Act, and the rise of mass incarceration. The last time Garland prosecuted an infamous domestic terrorist was Timothy McVeigh, the man responsible for the 1995 Oklahoma City bombing that killed 168 people. Congress had just passed the Omnibus Crime Bill. Prison industry boomed and law enforcement multiplied and militarized. The war on drugs, crime, and immigration converged on black and brown communities, rural communities, marginalized citizens such as the homeless and mentally ill. The height of the tough on crime era signaled a cannibalistic iteration of manifest destiny. Right-wing conservatives exploited the tragedy in Oklahoma City by using the prominence of capital punishment and rage of resignation to focus attention on reducing the time between the death sentence and execution, establishing extensive new limitations on federal judicial oversight in state courts. They called it the Anti-Terrorism Effective Death Penalty Act. On its face, the Anti-Terrorism Effective Death Penalty Act imposed a 1-year time limit for death row prisoners to file a federal habeas petition. It also created an unprecedented differential standard of review that made state court decisions virtually indisputable. The only way a federal court can overturn a state court decision is if it was so unreasonable and unconstitutional that no rational jurist would reach the same conclusion. The Anti-Terrorism Effective Death Penalty Act contained numerous other procedural rules that so complicated filing a federal habeas that It initially caused a spike in executions as capital defenders struggled to figure them out and missed the filing deadline. While this may have restricted federal litigation of capital cases and only briefly shortened the delay between death sentences and execution, attorneys found other ways around it in state courts, and this in turn bogged down the process until capital cases languished under state review for decades. Nationwide, the average amount of time a defendant spent on death row slowly increased while executions decreased. The Anti-Terrorism Effective Death Penalty Act went far beyond capital cases, though, and destroyed the process of federal review for all criminal defendants, preventing them from using the courts to challenge the denials of their constitutional rights. The Anti-Terrorism Effective Death Penalty Act was a predictable result of politicizing criminal justice policy and was also part of the backlash to the civil rights era. Non-capital defendants bore the worst of the Anti-Terrorism Effective Death Penalty Act because, unlike capital defendants, they lack legal counsel more often than not to navigate the procedural cuts we want habeas. Even the most fervent jailhouse lawyers struggle to meet the one-year deadline, let alone get past the procedural bar against issues not raised at the state level. Prisoners with legitimate claims of police, prosecutorial, or jury misconduct, ineffective counsel, disproportionate sentences, and clemency were ignored. Even if a defendant presented evidence of legal innocence and a state appellate court upheld his or her conviction, under the Anti-Terrorism Effective Death Penalty Act, the federal court could acknowledge that the person was probably innocent, still defer to state court decision. In the time since I fought to overturn my own wrongful conviction sentence, I've learned a lot about criminal procedures, rules of evidence, expert testimony, ineffective assistance of counsel, false confessions, and a pattern of prosecutorial misconduct. The harsh reality is that the criminal legal system has nothing to do with truth or justice, and the Anti-Terrorism Effective Death Penalty Act is all the evidence one needs. My trial lawyers got a lot of things wrong, not just their representation of my case. After the jury rendered its verdict, I asked how long until I had it before the state executed me. Don't worry, said my lead attorney. You've got appeals. Maybe 10 years, sometimes more. 2 or 3 years for a direct review of the trial record. 4 or 5 years for the state level habeas, known as a motion for appropriate relief. 1 year for the federal habeas petition. Maybe a few months for clemency. You might even win, he said as they took me away. All of it was a gross oversimplification, and none of it reassured me. 31 executions were carried out in my first 7 years on death row. Then litigation over doctor participation in drugs used in the lethal injection initiated a de facto moratorium. Many of the people were strangers. Some were friends I still think about, but all of them were human beings fighting for their lives just like me. In the brutal moments after someone is put to death, understanding criminal justice policy and the law becomes a matter of survival, but it's like dying of thirst, sipping from a fire hose to quench it. Prior to the passing of the Anti-Terrorism Effective Death Penalty Act in 1996, the average span of time between trial and execution was 10 years. By 2015, that time span increased to nearly 19 years. Death penalty states like North Carolina, where no executions have occurred since 2006, the span of time prisoners spent on death row has become the equivalent of life imprisonment with a remote possibility of death. The Anti-Terrorism Effective Death Penalty Act, in other words, had the opposite of its intended effect. Rather than shorten delays, it doubled them by reducing federal judicial oversight. It forced state courts to step up their scrutiny of capital post-conviction appeals. For example, in North Carolina, by 2015, over 70% of all death sentences were reversed on appeal. 12 people have been exonerated between 1973 and 2020. The fact is, without judicial scrutiny and legal representation, the number of death sentences reversed
You have 60 seconds remaining.
would be dwarfed by executions. When a death sentence or conviction is vacated, it may be a glimpse of justice, but the process also exposes how difficult it is to achieve equal justice in a system not designed to help those it impacts. The criminal legal system isn't really broken. It works exactly as intended. The Anti-Terrorism Effective Death Penalty Act, Omnibus Crime Bill are simply examples of that. If anything, our trust has been broken.
You have 30 seconds remaining.
Are supposed to rise above the mob mentality desire to seek revenge. Do the right thing for the poor and marginalized, not embrace the status quo for half measures. True justice has no exceptions, but embedded within the first 13th Amendment's prohibition against slavery,
Hello?
You have a prepaid call. You will not be charged for this call. This call is from
Lyle May.
an inmate at Central Prison. This call will be monitored and recorded for purpose. Thank you for using Global Tail Link.
Hello.
Yeah, you're back.
Sorry. The Food Justice has no steps yet vetted within the 13th Amendment prohibition against slavery. There is a loophole through which millions have gone and will continue to go as long as populist politics determine criminal legal procedure instead of equity. Rather than pick at the threads of the rope, minor reforms, as I have now witnessed 5 presidents do, it's time to dismantle the scaffold. That's the first part of my discussion. The second part, I kind of go into some of my more, I should say, legalistic writing and discuss a law review I had published through Brooklyn Law School's Journal of Law and Policy. It's important to bring attention to damning policies like the Anti-Terrorism Effective Death Penalty Act. Calling for its repeal can feel very removed when fighting for relief from one's sentence conviction. Also, while legislation maintains the structure of the carceral system, state law established in the judiciary determines how it functions. This is what makes the politicization of courts such a difficult problem, especially when the U.S. Supreme Court actively erodes or ignores 4th, 5th, 6th, 8th, 14th Amendment rights to criminal defendants. As if this wasn't bad enough, when Cindy Ramirez in 2022 demonstrated how much lower the court's conservative majority would go, writing to the majority, Justice Clarence Thomas gutted the federal court's ability to safeguard the effective assistance of the counsel at the post-conviction level. The court overruled the relatively recent precedents set by Martinez v. Ryan and Trevino v. Taylor, holding that defendants are at fault for any claim not raised during state post-conviction proceedings.
This call is from a North Carolina correctional facility.
Justice Thomas stated that the petitioner bears the risk of federal habeas for all attorney errors made in the course of representation. In other words, if your attorney screw up, miss a deadline, forget to include information in the brief, fail to investigate, or do such a poor job that cumulative errors result in substandard performance, it's the defendant's responsibility to raise it at the state level. The issue, or the issue is procedurally barred. It's reasonable to say most prisoners pursuing appellate relief recognize attorneys' mistakes. It's why each of us is, in some ways, responsible for assisting in his or her defense and bringing things to an attorney's attention. Sometimes, though, conflict occurs and assistance is seen as interference. The true danger of the indecision manifests. I researched in while writing State Delay on outdated capital post-conviction defense tactics undermining effectiveness in the attorney-client relationship. A law review article for the Brooklyn Law School's Journal of Law and Policy. State of Delay, like my writing in Witness, was an effort to illustrate and explain complex facets of the appellate process, but also seek accountability from attorneys hired to represent capital defendants. Sin makes that accountability necessary. Yet, my questions and attempts to interview attorneys ruffled feathers. Part of the negative sentiment comes from ego. I'm just a prisoner, questioning trained professionals after all. The other part comes from the very place I thought the kind of light of accountability, that those on death row should be grateful for any help they receive. The problem is that attorneys have a duty to pursue client interests, tailor defense strategies, specifics of the case, not implement one-size-fits-all tactics that ignore potentially exculpatory evidence or keep people on death row indefinitely. Confirmation of generalized capital defense tactics and why they're problematic came from 2 unusual sources: the ABA guidelines and director of the ABA Death Penalty Representation Project. The American Bar Association Guidelines 10.5 outlines counsel's duty regarding case, attorney-client report, and uncooperative clients. It also provides commentary on the quote-unquote problem, which generalizes defendant mental faculties encompassed in an entire class, stating that anyone charged with a capital offense is likely to be anxious, distrustful to the point it impairs reasoning. ABA guideline 10.5 goes so far as to state, and I quote, "The prevalence of mental illness and impaired reasoning is so high in the capital defendant population that it must be assumed that the client is emotionally and intellectually impaired." End quote. The ABA guidelines, upon which the term build practical applications of legal strategy, presuppose that anyone charged with a capital crime is unlikely to comprehend the dire nature of the situation or effectively assist an attorney in development of legal claims. By attaching the phrase complete denial in the face of overwhelming evidence to a list of psychological impairments an attorney may encounter in a capital client, ABA Guideline 10.5 suggests that denial of guilt is itself a form of psychosis. It fails to divine overwhelming evidence. It's confession. Overwhelming evidence until later discredited, eyewitness testimony until disproven or recanted, junk science, and even some DNA evidence has been used as overwhelming evidence against innocent people who were later exonerated, and in some cases after being executed. In reference to the assumption in Guideline 10.5, the director of the ABA Capital Representation Project claimed defense counsel aren't raising harmful, baseless claims. Their clients are impaired in some way, but rather that counsel fail to recognize these impairments exist. So it makes sense to err on the side of caution and be on the lookout for these issues. The director denied that the wording in Guideline 10.5 needed to be changed, claiming they were written to be broad enough that they would continue to apply so long as law and science involved. The irony of this last idea, as law and science evolve, came when I asked the director to clarify why the ABA guidelines have not been revised since 2003. First, he claimed the responsibility of those revisions would fall on her department, take away from their limited resources. Then, the director warned that it was dangerous to revise the guidelines because the 2003 version received near unanimous support from across the broad spectrum of legal actors, but that in today's political climate, the same would not occur. The conservative court, which has no respect for precedent or the evolution of law and science, would potentially nullify cases such as Beard v. Rompilla and Wiggins v. Smith, cases that are based on the 2003 ABA guidelines that emphasize mental illness and intellectual impairment, which made it easier to raise ineffective assistance counsel claims. Law and science cannot evolve within the review of any conservative court because the concept of an evolving standard of decency has long been opposed by these constitutional rigorists. What the director revealed, as did others I interviewed for debate delay, merely
This call is from a North Carolina correctional facility.
Merely emphasized Justice Thomas's threat. A successful appeal is the defendant's responsibility because sometimes the help preferred by attorneys is a little more than a check in a box. If, as ABA Guideline 10.5 states, most capital defendants are intellectually disabled or mentally ill, then holding defendants responsible for attorney errors is indeed cruel. But just as ignorance of the law has never been an excuse when getting punished for violating it, neither do prisoners have the luxury of assuming their rights are more than a suggestion. But both the U.S. Supreme Court and the ABA guidelines have shown ethics and fair treatment when it comes to capital defendants are optional. But what does this mean? Accountability comes in different forms. For my part, I write and analyze the politics and policies of mass incarceration, illustrating that analysis with examples I've experienced or witnessed. One of the more interesting developments to come from state delay was in the lead up to its publication, who I interviewed wanted to essentially edit their responses to my questions. One attorney went so far as to contact the editor-in-chief of the Journal of Law and Policy and insist that she'd be allowed to review the contextualization of her interview. She was refused, but did get to see how I quoted her. On doing so, she then unasked sent revisions to the journal's editors that took the edge off her initial callous response. The revisions, she that were ignored, and the article went to publication. The lessons I took from this experience was that some people in the legal field are arrogant enough to believe they don't make mistakes and are not at fault for substandard representation or the obstruction of due process. This strikes at the heart of state of delay, but also why I write about the criminal legal system. And that counsel can be well-meaning and think they're doing a job that meets professional standards and still provide ineffective assistance to counsel that meets both prongs of Strickland v. Washington. If the courts are becoming deaf to constitutional violations experienced by criminal defendants, an individual within the ABA or CLEs designed by them seek lawsuits and attorneys' flawed practice. The real problem becomes one of systemic oversight. Director of the ADA Capital Representation Project eventually admitted that the assumption in the ABA guidelines runs the risk of teaching an implicit bias when it comes to capital cases. She even claims she would pay more attention to it in her own teaching. This is small consolation for those on death row who must fight past their own attorney's bias. Implicit bias has a way of undermining effectiveness and professional conduct in every field. We see it all the time in law enforcement. Generally speaking, if the American Bar Association is the ultimate governing body of legal practitioners, it should also be holding the same practitioner to the highest ethical and professional standards, yet it fails in its duty. Ideally, when those standards are not met, censure is far to follow. When a prosecutor, for example, suppresses evidence and uncovered by the court, that misconduct should land the attorney before the state bar, fighting to keep their law license. The same applies to judges with obvious political bias and complicity in national or local politics. If indeed no one is above the law, then that means holding those who practice it accountable. As an incarcerated journalist that pushes back against the misinformation, I strive to be critical of the information I consume and relay. I source my articles as much as I possibly can, and they often sound academic. It's the thing I'm most proud of, to be perfectly honest. Why? Because its movies and crime dramas sensationalize the worst elements of prison, glorify law enforcement, and mainstream outlets regurgitate state narratives. Pushing back against these narratives becomes imperative in the fight for human dignity and against authoritarianism. The normalcy of exceptional brutality is the systemic devaluation of life in the margin that begins with otherism and evolves with the very assumption and justification for punishment. That is the essence of the American criminal legal system. Come from a marginalized group, get charged with a crime and imprisoned, and you lose your claim to constitutional protection afforded to the majority. Where civil discourse can be thought of as normative, so too is the idea of punishment as vengeance, diminishment of others. In that distancing of human life and potential is squandered and crime results. Prisons are criminogenic because they have always failed the mercy test. Similarly, the legal system is criminogenic because it makes exceptions in this application of brutal, senseless policies. The best way to address this is to pursue due process, justice for everyone, and accountability for bad actors is in fact through the evolution of law. But evolution is not an inactive process. It takes a lot of hard work, a little bit of courage, and an unwillingness to be kept silent. Thank you. That's my remarks, and I'll open it to questions now.
Lyle, do you want to call back? Because you have about a minute.
Yep.
Okay. Okay, so just hang tight.
Thank you for using Global Tel Lane.
Hi. Okay, so I think maybe folks in the NLG might have some questions for you to start with.
Lyle, those remarks were fantastic. Thank you for sharing your story and passage of your book. This is Maggie from the DC chapter. If folks, if audience members, people who joined us today have questions, please feel free to come off mute and share those. You can also write them in the chat. I have a question I'm going to put to you here, which is, if there was a single fix to the many problems defendants face when pursuing a due process on appeal, what would it be and why?
Thank you for that question. The term hanging judge refers to a jurist who is especially harsh with defendants as a matter of routine, especially those accused of capital crimes, and sometimes corruptly so. It doesn't matter what the crime is, and these types of judges hand down some of the most punitive sentences in the criminal legal system. This comes from the fact that most judges were prosecutors first. When they become judges, if they engage in misconduct as a prosecutor, that doesn't simply disappear if they put on a black robe. If anything, their power to do wrong and destroy lives increases. There is also the heavy influence of politics in all of this. What it takes to get elected to the bench is usually driven by fear of crime and ignorance of criminal legal system cronyism. Combating all of that can't be fixed by a single policy, but removing immunity from prosecutors
This call is from the North Carolina Correctional Facility.
and requiring judges to also, at one point in their legal career, be defense attorneys would go a long way toward injecting more integrity into the legal system. No court actor should be, first of all, no court actor should be immune from liability, especially when it allows the worst sort of corruption and human rights to take place. And second of all, if you are a judge and you're determining both sides of an argument, you should have had the opportunity to be on both sides.
Maggie, do you want to ask another question, or you want to?
For sure. So, why should ordinary people who have no direct link to or understanding of the criminal legal system care what happens on appellate review of a criminal case?
Well, the short answer is that appellate review is the Fifth and 14th Amendment's guarantee of due process at work. I can't emphasize enough that without due process, the whole idea of justice evaporates. Whether you seek justice for police brutality, election integrity, bodily autonomy, or relief from a wrongful conviction, or even relief from an extreme sentence, due process allows us to seek redress through the judicial system. When that fundamental right to access and review is blocked, undermined, diluted, or altogether ignored by politicized courts, such as what we see in the Supreme Court of the United States, then fairness, freedom, and democracy suffer. So it absolutely impacts everyone in this country.
Maybe I'll ask you a question, Lyle. So if you were going to give the newly arrested 19-year-old you advice, what would it be and why?
That's a tough one. I was, like many 19-year-olds, very naive and too trusting and wholly ignorant of the law. There was not much more I could do to help myself in the moment after getting charged with capital murder. Much of the next several years were spent wrestling with my mental health. If I could have given the 19-year-old me any advice that would have been useful, it would be to shut up and listen to the things that I knew in my heart were right. Those lessons, that mom and dad teach you about character, work, and worth. The guiding principles of life, so to speak, the ones you need to survive, that I would need to survive what was to come, and have already been, had already been instilled, because ultimately I had to go back and rediscover those things, and it was definitely a struggle.
So let me ask you another question. Obviously, you've written quite extensively, both including Witness and your forthcoming book called The Transformative Journey of Higher Education in Prison, a Class of One, which will be available for pre-order for anyone who's interested in July. You rely on different academic sources. And so if you were going to recommend books on the urgent topics you address, which would they be?
Well, I use a lot of books, and have used a lot of books over the years when I write articles and books. I think some of the ones that I've relied on the most recently, and I'll give you five, because otherwise I'll just start listing a library full of books. The first one would be Stephen Breyer, Against the Death Penalty, which is edited by John B. Bessler, and essentially it's just a book of Stephen Breyer's defense against the death penalty. But it also includes like an introduction of the case, which is philosophy growth. And it's one of the reasons this book is so particularly interesting and important is that all of the things that Breyer talks about as reasons for not having the death penalty were the very same things that got the death penalty abolished in 1972. And we're still experiencing these things. So, he makes an excellent case against the death penalty. Similarly, Cruel and Unusual, The Punishment U.S. Culture by Brian Jarvis. Not quite as technical or nuanced in terms of legalese, but Cruel and Unusual discusses different cultural ideas and books and movies that have drawn from, punishment U.S. culture, and not quite the thing that you would ordinarily think about when research for any kind of article on death penalty, but you think twice about that when you realize a lot of the influence the criminal legal system has on books and movies and vice versa.
This call is from a North Carolina correctional facility.
One of my favorites is Prisoners of Politics, Breaking the Cycle of Mass Incarceration by Rachel Lee Sparkow. And this is actually a phenomenal book that poses this idea of, well, instead of reforming or adding new policies in the criminal legal system or doing away with a particular policy, she does something else entirely and talks about turning the criminal legal system into an agency, much like the FDA or something along those lines, removing the politics from the application of punishment for crimes and sentencing. Rachel Lee Sparkow was actually on the U.S. Sentencing Commission, so she has some good expertise in talking about this, but also has a fantastic breakdown of different policies related to both convictions and sentencing, and certainly the politics and policies of mass incarceration. Similarly, Breaking the Pendulum, The Long Struggle Over Criminal Justice by Philip Goodman, Joshua Page, Michelle Phelps, really does a deep dive into the shifts in penal policy that have occurred since essentially 1865 and the the end of the Civil War and end of slavery. Breaking the Pendulum kind of bucks the myth, so to speak, of this idea that there's a swing from ultra punitive to ultra liberal sentencing and punishment practices, and talk more about how there's a layering of policies and shift in policy that is much more like the shift of tectonic plates than it is an actual pendulum. And then finally, death by prison, the emergence of life without parole, perpetual confinement by Christopher Steeds is exactly what it sounds like. It is the history of life without parole, which many people think has been around forever, and it really hasn't. It's a relatively new thing that really took flight in the mid 80s and then just really metastasized with the tough on crime area of the 90s. So those would be like my top 5 recommended books.
And maybe just one more question before we hand it off to the audience. So could you talk a little bit about the blatant politicization of the U.S. Supreme Court and lower courts of jurisdiction and the way they changed incarcerated people's understanding of the criminal legal process?
Sure. For those of us paying attention and who understand that a conservative judiciary means one deaf, dumb, and blind to our constitutional rights, it's hard not to despair. But prison, if nothing else, how to fight despair. Politics have always been within the calculus of how an appeal is received by a given court. Now it's increased. In North Carolina, for example, the current makeup of the state Supreme Court is a 5-2 Republican majority. Prior to this shift in 2023, North Carolina prisoners had at least a small chance of relief when their claims reached the state Supreme Court. That window closed with the conservative court. In fact, the court has worked to overturn precedents set by the previous court that helped not just incarcerated people, but marginalized minorities and LGBTQ plus individuals. The criminal legal system has obviously never favored incarcerated people, but there were periods where it was less hostile toward relief and more concerned with constitutional protections. Now it's one of those times, and it's incumbent upon now it's not one of those times. It's incumbent upon anyone pursuing due process where awareness, of course, is only part of it. With awareness comes the need to constantly seek new ways to apply the law to counter the overwhelming disadvantage of that conservative judiciary. It means fighting smarter and harder.
Thank you so much, Lyle. Does anyone from the audience have any questions? You can either raise your hand or stick it in the chat. And if you haven't already gone to Lyle's link tree, I put it in the chat a couple of times. Again, it has a link to his book Witness, as well as the forthcoming book, a bunch of op-eds, and links to review the books on Amazon and Goodreads. So any questions from the audience? Elizabeth, you had a question?
Hi, yeah, this is Beth Kingsley. Thank you so much for this talk. I read your book and I strongly recommend it to anyone on this call. One of the things you talk about, and one of the things I find very frustrating, is the strength of the law and order narrative, and when people in the community and when the public gets scared, when they at least perceive an increase in crime that threatens them, they accept those arguments sort of unthinkingly. And I'm wondering how to affect, and I guess I'm asking if you have thoughts. I don't know that you have the answer, but how can one push back against that narrative when people are reacting from a place of fear?
Okay, and Lyle's gonna have to call us back.
I'll back in.
I'm sorry, will we cut off? Should I say it again?
He has to call back because he can only talk for 15-minute increments.
Right. Okay. I couldn't tell when the
Sorry. It
I'll
just,
just wait. Thank you.
yeah, sure. So he should be calling right back. And thank you, Sanat, for the question. I will ask him. Hello?
You have a prepaid call. You will not be charged for this call. This call is from
Lyle May.
an inmate at Central Prison. This call will be monitored and recorded for customer assistance. Thank you for using Global Tel Lane.
Hello.
Hey, okay, you're back.
So you asked a really good question, because one of the things that we know is that when people are afraid, it's hard for them to be rational. So it's even harder to give them rational arguments for why one policy or another isn't the effective response. So that means you really got to do a few things. First of all, you can't tell them not to be afraid, because obviously that's not going to work. But I think it would help to say, okay, I understand your fear. You have a right to feel that way. But what we don't have a right to do as a society or as a community is to bite onto or have this knee-jerk reaction to, oh my God, we have to do something violent or vengeful or ultra punitive in response to this rise in crime. You see a great example of this is, there's been an uptick in, say, like break-ins and storefront robberies, while the statistics have been showing there's actually been a decline in murders. But of course, that gets lost in the flashiness of these people who are, breaking into these storefronts and, mobs and riots and things, or, protests that get out of hand. And, you have bad actors who are going to take advantage of these circumstances and foment fear. So in terms of doing or addressing this, first you have to address the bad actors. You have to find ways to disrupt the narratives that they're engaging in, and that means going to where they're at in terms of their social media platforms, the circles that they travel in.
This call is from a North Carolina correctional facility.
You go to their conferences and you call them out. You find ways to inject rational statistics in those places, because more often than not, we know that they're going to be thinking at least clearly long enough to understand what you're saying. For the people who are feeding from, or I should say, for the people who are being fed these narratives, it's much harder. It's hard to convince an elderly couple that they shouldn't be voting for this particular bill or that particular lawmaker just because they're claiming that they're being overrun at the border, or that they're all these violent criminals are going to come to get them. It's literally the kind of thing that you hear about campfire boogeyman stories. Not that crime happens, please don't misunderstand me. Just that it's that kind of idea that's used to take advantage of these voters. So it's important to again, you recognize the fear. You say, I see what you have to be concerned about, but have you ever considered this idea? And then you kind of go from there. And I guess that's really the best that I can give you. It's certainly a question I'm certain lawmakers themselves are trying to deal with, as well as criminologists.
Okay. My friend and colleague Sanat has a question for you. And her question is, do you have any observations about how to address an increasing desire for punitiveness and retribution in American culture as part of our carceral state?
Thank you for that question. And that really speaks to that idea of the norm of exceptional brutality, or even how in death penalty states when you have active executions, crime rates increase because the death penalty, as we know, or brutality itself is criminogenic. It's this brutalization effect that the more violence is engaged in, the more it creates violence. It is literally a vicious cycle. It's often why prisons are violent, not because, that people run amok. It's just that, there's this absolute lack of mercy. So in terms of addressing that, it's kind of a similar question to the previous one. Is you have to do this in many different ways. You would attack the source of the information, the source of this brutality, and then you also find people who are affected by it the most. Not so much those of us on the inside. Of course, we're always going to be affected by these things, but those on the outside who are making these maybe irrational decisions when it comes to supporting the more punitive and vengeance reflex.
Does anyone else have? Sanat, does that answer your question? I know you're in the chat, but let us know. Does anyone else have questions for Lyle? She says it does. Thank you.
Okay.
Any other questions? Well, if you haven't already read Witness, you definitely should. And either way, please share the book information about it with 5 friends, just to make sure that, folks are getting the word out and can support Lyle. That would be really great. Let's wait like another minute. If anyone has any burning questions, again, you can feel free to say them out loud or stick them in the chat. Otherwise, I will hand it back to Maggie. Well, Lyle, do you have any final thoughts you want to share?
Sure. And this kind of gets back to the previous 2 questions I was asked. And a lot of what bad criminal legal policy is a lack of accurate information. And the only way that we can provide that accurate information is, one, meeting misinformation wherever we find it, whether that's in the news, whether that's online, whether that's in the line at a voting poll, wherever you find it. And I know that sounds maybe easier said than done, but it's very important that we are tireless in countering that misinformation, that we are tireless in fighting back against the idea that vengeance is the best way to address crime. And then also it's important to provide solutions. And by solutions, I mean specifically crime prevention ideas. Prisons are very much after the fact when it comes to crime. And very little, it seems, is being done about addressing crime before the fact. And that's kind of the whole idea behind abolition and prison abolitionists. We're interested in reducing the carceral footprint. And to do that, we have to implement.
This call is from a North Carolina correctional facility.
We have to implement policies that disrupt the school to prison pipeline, that keep kids in school and off of the streets, and certainly reduce the need for prisons altogether. That of course means addressing domestic violence. It means implementing more programs that help those who are substance abusers and taking care of crime before it happens.
Well, you've gotten a few notes of gratitude from Zev, who says, thank you for sharing these ideas and argument. And Anais, who says, deeply grateful for this opportunity to listen and learn. She's looking forward to reading your book and sends you solidarity. So I'll hand it back to Maggie, but I just want to thank you all for attending. And because I didn't get a chance to in the beginning, just thank Maggie and Marquise and Kiana for helping put this together, as well as NLG National, the Mass Incarceration Committee, and Jailhouse Lawyers Speak. It's not often that we get to hear from incarcerated voices, so really grateful to all of you, and also Jennifer for setting the context and tone, really important words. And as we all continue to move forward and struggling to fight against mass incarceration, hope you all will heed Lyle's words, and most importantly, buy his book and share all his thoughts.
Thank you so much for that, Maha, and thank you so much, Lyle, once again for sharing your really profound thoughts and reflections on the carceral system and kind of how it's impacting you and the communities that we're all part of. I really appreciated hearing from you this evening. I actually want to just pass quickly to Jen if she has anything else that she'd like to add. The speaker here this evening as well, before we close out.
No, I just wanted to thank everyone, and certainly Lyle. It's been a rich conversation, certainly insightful, and I'm really honored and grateful to have been here. Thank you.
Absolutely. And grateful for everyone for joining this evening. We'll have to have you back, Lyle, for your upcoming release. That sounds like a really interesting book. Story of one with higher education. I'm looking forward to delving into that one as well. So thank you, everyone. Thank you to our co-sponsors. And thank you, DC and LG, for being a rock star chapter within the National Lawyers Guild. Only abolitionist bar association.
Yes.
Yes.
Thank you, and I certainly appreciate the ability to talk with all of you this evening, and definitely look forward to the next time.
Do we all? All right. Bye-bye all.
Bye-bye. Thank you again. Free them all.
For them all.